So, this video is all about how well protected your civil liberties are in the UK. But let's first define what we mean by the term civil liberties. These are those freedoms and rights that the citizens of a state enjoy in relation to its laws. Before the year 2000, freedom in the UK was entirely negative, meaning that British citizens could do anything that didn't contravene UK law. For example, there was freedom of expression, but only up to the point where limited by the laws of libel, slander and blasphemy, etc. This made it very difficult for citizens to understand the extent of their rights. Rights in the UK could technically come and go with ease due to parliamentary sovereignty, because Parliament is defined as omnicompetent and therefore can pass any law that it wishes. As a result, the Labour government, elected in 1997, introduced two new measures, the Freedom of Information Act 2000 and the Human Rights Act 1998. The Human Rights Act came into force in 2000 and codified in UK law the European Constitution on Human Rights 1950. This would prevent the long drawn-out process of legal appeal to the European Court of Human Rights in Strasbourg. There was one issue with the Human Rights Act, and that's that Parliament refused to give up their ultimate sovereignty, and so were allowed dispensation to introduce laws that contravene the Human Rights Act. These laws then stand instead of the Human Rights Act. Essentially, this has created a hierarchy of law in the UK of common law, Human Rights Act, and statute law. There is, however, one other safeguard. A citizen can challenge a statute law on the grounds that it is incompatible with the European Court of Human Rights. This is what happened with the Belmarsh case in 2004. 8 suspects were detained under the Anti-Terrorism Act 2001 without a trial in Belmarsh prison. An appeal was made to the then law lords, 8 out of 9 of whom agreed that the detention of suspects without trial violated the European Convention on Human Rights. This did not invalidate the Anti-Terrorism Act, as it was a statute law. However, the political and media fallout was strong enough for the government to amend the Act. The Belmarsh case shows that, if it is significantly high profile, a court ruling can still influence and direct Parliament. But how well do the judiciary protect your civil rights? Well, on the one hand, the Human Rights Act has given the judiciary a codified act of rights upon which to judge threats to civil liberties. The judiciary can justifiably claim to be independent from political influence, and the Supreme Court is far more politically neutral and independent than the law lords were. On the other hand, parliamentary sovereignty means that statute law is the highest authority in the UK. The Human Rights Act is not binding on Parliament, judges are not elected or accountable to the public, and the conciliation fund from which they're paid is still funded from Whitehall. Therefore, in our uncodified constitution, civil liberties are protected as far as Parliament desires. The Human Rights Act, creation of a Supreme Court, and the Belmarsh case, however, also show that UK citizens are in a better place than ever before in terms of civil liberties. Thanks for listening.